And as a trial judge, I have to make sure everyone that wants to serve has a right to serve, and they can be contacted. This has nothing to do with advocacy on behalf of any party. It's not. I didn't even think about it, but Mr. Kemp said, Judge, this could open us up to a Batson challenge. I don't want a Batson challenge. This is an issue of justice and the right of the citizens of Clark County to serve.
All rise, Department 16 is now in session. Judge Williams now presiding. Be seated.
And thank you, ma'am. Anyway, let's go ahead and set forth our appearances for the record.
Will Kemp for plaintiffs.
Good afternoon, Your Honor. Eric Pepperman for plaintiffs.
Good afternoon, Your Honor. Scott Rasmussen for Hanna Instruments and Commissioner Witt, Christian Camino.
Good afternoon, Your Honor. United Natural Foods West, David Spurlock.
Okay, and I guess we have appearances online, right? Let's go through the list.
Laureen Frister for Cahey Distributors, a non-party in the Gallagher matter, just observing today.
Good afternoon. Joel Odou on behalf of Real Water and Affinities Lifestyles Inc.com. And also at the deposition room, I have Jim Cavanaugh for third-party defendant Real Water, Tennessee.
Good afternoon, Your Honor. Todd Moody, bar number 5430, co-counsel for Hanna Instruments and Milwaukee Instruments.
Good afternoon. This is Michel Anastassiou, bar number 15697, appearing for defendant Milwaukee Instruments.
All right, does that cover all appearances? I think there should be more, right?
There's some that are just observing. We'll check in.
Huh. Okay, once again, good afternoon, and we set this matter up as a status check in anticipation of the upcoming trial that's currently set for this fall. And really and truly what we need to do is actually start some planning sessions. And you can see we've actually taken a somewhat proactive approach as far as the trial is concerned. And we actually have brought in to discuss what the issues are. It would be our commissioner, our jury commissioner. And so anyway, I know there were a couple of issues. I know, Mr. Kemp, at the last hearing, you had discussed, you hadn't talked to your experts, but hopefully that's not a non-issue right now.
Appears it's going to have to be, Your Honor.
Okay. I understand, right? Anything from the defense?
Not at this time. We'll be pleased to hear from the commissioner on this thing, and we'll let you know that our firm is defense counsel on the Ramirez case.
Okay, I understand. Well, we don't have to worry about that case because that one will go to trial and this one goes to trial. So both have firm trial settings, and this is a trial management issue. And what I try to do on larger cases like this, I try to get ahead of the curve. I really and truly do. And so anyway, we've actually been working, and we have Mariah. She's our jury commissioner, and she helps coordinate sending out the summons as far as juries are concerned. And actually, I think, Mariah, we have a two-step process in place right now. Is that the best way to say it?
Yeah, that's what we're working on.
Okay. And so I guess what I want to do, if you take it, and we've emailed these out to everyone, and I don't know if everyone has a copy of them, but we have a questionnaire that goes part and parcel with the summons that specifically deals with the issue of time qualification. Is that correct, ma'am?
Yes.
All right. Has everyone had a chance to look at that?
Yes, Your Honor.
Yes, Your Honor. We've looked at the ASQ, and I don't have any problem with it.
Judge, I have a minor concern. Maybe it's a major concern. Studies have shown that anytime we do online surveys that they're potentially discriminatory to people that don't have computers or access to electronic devices. And for example, the school district, as you're well aware, they see this problem all the time. And that's why we have all these drives to get computers for the poor part of the state. So if you require everything done online, in effect, we're creating a potential Batson problem. because we are
I
eliminating.
understand. I
Yeah,
do.
we're eliminating the whole segment of the population. I'm sure the jury commissioner's thought of that, and she has a solution to that, but it just can't be all online. Because let's take the case of, let's say a 70-year-old Hispanic woman living on the east side that we send one of these to. She doesn't have a computer, okay? She might not even have a mobile phone. If she does have a mobile phone, it might not be compatible with this survey parameter. I don't know. I don't know how it's designed, whether it's compatible, whether it only works on certain versions of iPhones, whether it only works on certain versions of Samsung, whether it'll work on the cheaper phones that T-Mobile and the other companies issue. I don't know. I don't know if it's phone compatible. If it's not phone compatible, I think we have even a bigger problem than I raised in the first place. But in any event, I get.
And I don't want to cut you off, but that woman would have a right to serve.
She would have a right to serve, Your Honor, but
I understand.
if we're doing online screening as the first test, there's got to be a method where, personally, I think if it's online screening for hardship, I don't know why we're doing that. I think we could mail it and put them return envelopes. If it's a cost thing for the return envelopes, I'd be happy to pay the cost. Plaintiffs, whatever the cost is for 1,500 return envelopes. I just think you create a huge problem here when you try to whack people off in the first instance with an online survey that you can only answer with a computer. And maybe the jury commissioner has experience with this and there's a solution, but I do know from all the studies that I've seen that is potentially discriminatory.
Thank you, sir. Anyone else has any questions in that regard? All right. Ma'am, we can turn it over to you because that's something I don't necessarily know about.
So we do have that. It's actually even on the questionnaire. We can offer people, if they say they don't have access to a computer, we have kind of encountered that and built that into our proposed timeline to allow jurors to actually, they can come in person and fill it out with us here. We can do that with them, or they also have the option they can talk to us and we can complete it on the phone for them and make note that that's what happened, is that we entered it for them with an agent.
Or what about sending the responses back by mail? Can we do that?
I can do a hard copy one that we can mail to people that say that they would have to return it by that return date. I mean, that's the potential where we could have that.
Well, that's what's great about getting out far in advance.
Yeah, I'm fine with that, John. I just think if you rely upon computer only and then you have an additional step that the people that don't have computers have to take, that's discriminatory. That's making them do another step to potentially be in the jury pool. And so I would much rather just mail them something and have them have the option either to mail it back or to go online. Give them the option, and then maybe some sort of, if the online isn't back or the mail isn't back by X date, there should be some requirement that they come down here. That shouldn't be out of the equation.
All right, I understand. I do. And ma'am, what's your response?
We can certainly have a hard copy available that we can send to them, but we just, in another case, did complete an ability to serve questionnaire, a very large one, with in fact, 15,000 of them. And we had a pretty good response, and
What any idea what the response rate was?
Well, in any pool that we create, just right off the top, you're going to have at least probably 50% that are not going to be people that are going to be able to complete the questionnaire anyway, because either they're disqualified, exempt, excused, or postponed for whatever urgent reason, or just not responded at all. So you do have to take into account for that and mail more right off the top. I want to say it was a lot higher than normal. I want to say it was about 60% as opposed to 50. It was a little bit higher for the online. And then, of course, as we went to the next step, when we did the written questionnaire, the response rate was even higher because at that point they'd already been contacted, they'd already been responded, they already knew they had to come in. But to have exact numbers, I don't have the exact numbers. I want to say it was somewhere around 60%.
All right. I mean, I don't mind addressing the issue head on because one of the concerns I have as far as service is concerned, everyone has a right to serve. So I want to make sure that when these go out, they go out to, number one, anyone that would come under the requirements. Number two, they have an opportunity to respond, an equal opportunity to respond, I should say it that way. So how do we deal with that specific issue?
Judge, I think you got to mail it out and have a return envelope. That's the only way I can, because, you know, here, maybe the jury commissioner thinks a 60% response rate is fantastic, but, I mean, that means 6,000 people didn't respond. That's 6,000 out of 15,000 didn't respond. How many of those didn't respond because they couldn't turn on a computer? Okay, I don't know. And they didn't want to call up the jury commissioner. I don't know. But it just seems to me it's creating a problem.
So the position of the defense is that I think the ESQ online is just fine. I think it gets out there. I don't mind putting another hard copy on top of that, but if they're responding either way, it's fine. 2023, I think an online thing like this is something that is expected. So that's our position.
Mariah, as far as, how would we handle this procedurally if we wanted to send them notices with envelopes? And I assume they would be addressed back to the Clark County Regional Justice Center.
Yes, Your Honor. We don't want to get in the middle of it, but we will pay for it.
Yeah, I mean, so that's kind of taken care of, and that makes it really, that lessens, I guess, administrative costs. And is there a problem with doing it that way?
I think time-wise, yes. Yeah, because if you look at the proposed timeline, when you're talking about mailing, now you're talking about the time that it takes to print, to get them in the mail, to get them out in the mail. People don't always check their mail every day. We're under a much tighter time frame than we normally would be. It's one of the reasons that we would summon more to ensure that you have a larger number of people to pick from to get to a number that's reasonable that you need. But we do it right now in basically all of our cases for the qualification part, just initially anyway, not the ability to serve, but our regular qualification. That's all online. It is our process now, and we do account for that and build into those numbers. We summon more people to ensure that we hit the numbers that we need, make sure we have enough people. Certainly myself and my staff always work to be inclusive. And like I said, we have several options for that. We can either mail them a hard copy if they say they don't have access to a computer. We can offer them to come in and we can help them do it. Or we can, with an agent, do it over the phone where they give us those responses. We put it in there and then make note that this clerk entered these responses from this individual on this date at this time.
Okay. I think the issue is this: how do we know if they don't have computer access?
That's the whole problem, Your Honor. I mean,
right. I understand. I do. I get it.
There's access to computers at every public library.
That's the whole thing. You're creating an additional burden.
Wait. Yeah, I mean, that doesn't have to be. I mean, how often do people go to a public library?
Well, my family does.
Well, I mean, but your family's the exception. But how often do people go to a public library?
Right.
And here's my point, though. And this is overlooked. Not everyone has a laptop. Not everybody has an iPad. Not everybody has phones. I mean, they don't. You might have one, but I mean, and this is important too. I mean, I see these commercials on television regarding seniors and telephones and some plans they can go to. But not everybody has a quote iPhone. Some people have flip phones. I mean, this is depending on their economic status. And that's kind of what my concern is. I mean, I get it. I do. Because not everybody's wired, right? They're not. You know, I don't know what it is statistically. Someone could probably do some research on that, but not everybody's wired.
No, not everyone is, Your Honor. But we're sending out more than what's needed in order to.
But that doesn't cure the issue, because you're not. It's not a question of numbers, because no matter how many you send out, the people that aren't wired won't have an opportunity to respond. I get it.
I understand, Your Honor. That's why we What I would suggest, though, is that there are some instructions that may be a little bit more simplified, something along the lines of, if you do this online, you don't have to send this back in. Things like that, that would help us. And then okay, here's what we're getting as far as response.
Judge, I don't mind if they have an online option, but there should.
Okay. Thank you.
Right. Because that's the issue. The issue is not the number of responses. The issue is reaching the appropriate cross-section of citizens of the county, right?
That's correct, Your Honor.
Right. I mean, because what happens, you just get more responses and you get more people that have access.
Yeah, and I point out they send the jury summons out by mail. They don't send it out by email for this precise reason.
Right.
With regard to the ASQ, I'll just let you know that there's a few firms that have been identified in there that probably are not going to this particular trial, and there may be other ones that have now been added. That's all we can do. So, Commissioner and Your Honor, we probably have to make sure that we have that corrected for your use.
I was just a draft, just to be changed.
You're fine. I'm not criticizing at all. I want to make sure. I'm just saying that we probably just need to make sure that's done.
Yes.
Well, how do we finalize that? Because I'm going to get, I mean, at the end of the
Yeah,
day.
we need to get that out like tomorrow is what you're telling me, right?
Exactly.
And Judge, we can get our comments in tomorrow. There's a couple defendants like counsel said, not in this case. There are in other cases. We can have our comments in by tomorrow noon if you want.
Right, and if there's parties that don't get it done the way they're supposed to, then they're not going to be on this thing, and I can't help that. But we will endeavor on the defense part to try to get that taken care of. And I don't know who's online that I can hear and not muted, but that's all.
Your Honor.
Yes.
Your Honor, Joel for Real Water Online. Not everyone received the email from the court today. I'm with counsel for Real Water Tennessee. They were not, they didn't receive a copy. I just gave it to them, but we do want to make sure that all of the participants for the trial are listed on the questionnaire. And so I think it's a fairly easy task for somebody's staff to make sure everybody on the service list that has appeared in the case is listed on the questionnaire and gets a copy of it.
And that person is me, Your Honor, Jim Cavanaugh. We're in Houston at a depot today, and Gordon Reese, Scully Mansicani firm in Las Vegas, 6929. I didn't get a copy, and we're certainly here for a Real Water of Tennessee LLC. Want to be included in that.
Did you get that, Lynn?
Yes, Gordon Reese, Jim Cavanaugh.
Right. Okay.
I did not send it to all parties on the e-service list because I didn't know if they were on the consolidated or coordinated cases. This is only pertaining to this case.
So this Gallagher case, right? We understand.
So we'll get that straightened
We'll
out.
make comments by tomorrow.
All right, but I want to circle back because we have to have some sort of solution as far as sending out the summons for jury service and ability to serve questionnaire, and because I think we have to resolve that today, no later than tomorrow, as to how potentially we can handle that.
Your Honor, again, I think the position of the defense is that we're fine with an online questionnaire. It's being used.
But but this isn't a position of anybody. I'm just telling you this. And I don't have positions other than as a trial judge, I have to make sure everyone that wants to serve has a right to serve, and they can be contacted. This has nothing to do with advocacy on behalf of any party. It's not. I mean, and here's my point. I was on the jury commission. I understand what's going on here. You want to make sure you have a very fair representation of Clark County, and everyone has an ability to serve and a right to serve. I didn't even think about it, but Mr. Kemp said, Judge, this could open us up to a Batson challenge. I don't want a Batson challenge. Right? I don't want to go to a trial for 10 weeks and then have to come back and retry this case again. Especially if the problem can be easily cured before we start the process. And that's kind of my point, because to me it's not a question. This is not a substantive issue. This is not a positional issue. It's not. This is an issue of justice. and the right of the citizens of Clark County to serve and to receive a summons and have an ability to respond. That's all it is.
So the only thing that I suggested is that if the
Right, ladies?
potential juror,
Those are my externs, and they agree with me 100%.
if a potential juror gets one of these, okay, the summons, okay, with this ASQ in close, I assume that's what the commissioner is looking at doing.
Right.
And they choose to do it electronically, they do not need to send it in by mail.
I mean, that's okay, I guess.
That's what I'm looking at. Number two, Mr. Kemp suggested that his firm, yes?
It's problematic when you have both online, and I would recommend you do either or, because for the most part.
And we're going to do it, if she says either or, that's fine. We'll do the or.
Because when you're getting into if you have onlines and then paper and then you're trying to sort them all out, get them all together.
Okay.
Remember, a lot of people don't understand the devil is in the details.
Exactly.
There's only me, and I have a very small staff.
Right.
And when you're talking about adding parties, that's me. I'm building the questionnaire, and
Right.
I'm handling all the other stuff. So we're at a point right now, if you're looking at two-step and you're mailing, I think with the added time with postage and all that, I think time-wise, you're gonna run into trouble. I don't know that, because we go backwards. When I do questionnaires, even before what completely written questionnaires, we were asking for 6 to 8 weeks because it just takes that long for questionnaires to be completed, jurors to respond and get those to us, and then to get those to the parties to review them, send the excusals. Then you basically have to do that all over again because you're bringing them in physically to do an actual case-specific questionnaire, pretrial questionnaire without all the, once the hardship's already done. And then you're going to voir dire. So you're looking time-wise, it's going to be a challenge because I had a hard time even fitting it into this timeline all online.
Well, whatever the judge and you decide would be the
You
best.
may want to go back to considering one questionnaire and doing your hardships and everything together. I mean, if that's the opinion, because I just think time-wise, I don't think you have time to do both.
Hey, Judge, I don't mind doing one questionnaire, as she suggested. But I do think the hardship should be up front for the...
Oh, absolutely. We have to, I mean, and I think this is overlooked. Lynn, how many panel members did we have to bring in for just a 3-week?
180.
Yeah, and that's time qualification issues. It was just a 3-week trial that ultimately went 5 weeks. But my point is this, and this based upon experience, it appears to me that it's becoming more difficult to seat juries in longer cases. It takes a little bit more effort, right? And as you know, we've had big ones in this department, as far as length, 6 months, 5 months, and so on and so on.
Well, Judge, and also if we bring in a combined time qualification jury questionnaire with all your questions, we bring them in, say, beginning of July, and they're thinking, oh, we get to serve. No, you come back September 5. So that could be a problem too. Things change. It's hard to say.
And I don't think your responses are going to be any different. I mean, that's what we have typically with or without a questionnaire. That is those are the facts.
Unless you bring them in 3 weeks before trial.
Well, that's why we're
But
here
even
today.
then, you're still dealing with that.
Right.
Like when you got your 180 or 60, whatever it was you got, those people were people that had already responded, already been qualified, were already here. So we just took what we already had in the room and assigned them to the case. So this is a different ballgame because the people have not, we don't know which ones are going to respond yet. We don't know which ones are available. We don't know which ones, until they go through that qualification process, we don't even know that. So we already do that qualification process anyway with just the standard qualification questions. I shared with Lynn, another thing you could consider is if you wanted to go that written route and you wanted to get rid of the hardships, you could consider what we actually did in another department where on the date that they came in and did the written questionnaire, they did the written questionnaire that morning. And then in the afternoon, there was a hearing just to hear hardships, only for hardships. And then the questionnaire itself was just the case specific. So that's another suggestion.
But I would anticipate I'd have 4 afternoons dealing with hardships if we're going to send out 1,500 or.
Yeah, Your Honor. Usually when we go through the questionnaire and look at the hardships, usually counsel agrees to strike, 20, 30% of the questionnaire right away.
Right.
Well, time qualification is going to be the biggest problem
Right.
for this one too.
Well, I don't mind saying this, and when it comes to hardships, and I understand the statutory requirement, but and I think as lawyers sometimes we overlook this fact that not many people can take a hit and sit for 8 weeks or 10 weeks on a jury trial unless they are retired and or have some other independent income, or they work for the county or the state or something to that effect. But it is what it
Remember,
is.
Your Honor, that's the defense estimate. My estimate's still 4 to 5 weeks.
Well, I remember the discussion when you're 7 hours across. Did you say that? How long is cross going to take in this case?
Well, no, what I said is that we have at least 7 or 8 defendants, assuming for a second that each one on particular witnesses has an hour each for cross, then that's where you come up with that number. Right? It may not be.
Well, and here's the thing.
We don't ask and answer. If it's already been asked, we're not going to ask it again.
Right.
You're not going to let us.
And I've actually done some research on this because we had a case that took exceptionally long, much longer than it should. And I got to a point where about 2/3 started to try to bring out time clocks.
Right.
And I limited each side to 3 hours per witness.
I understand, Your Honor.
And,
We understand.
We only have 4 defendants in this case, not 7 to 8 defendants. We have Real Water, UNF, the distributor, which is pretty much the same as Real Water, Hanna, and Milwaukee. That's what we have in this case. We don't have 7 defendants.
I thought there's more than that, and I'll get back to you on some of this that I think might qualify differently. So we'll see.
Okay. And I want to circle back. I keep coming back to, and we have all these are different issues. I want to do one primary thing today.
Okay.
I want to make a decision as to how we handle the time qualification issue.
Okay.
Period. And I want to make sure I understand what all the options are, because I do understand the option as it pertains to the summons by sending out the notice, responding that way. I guess we have the old traditional way to do it, right, where we have them come in and fill out the jury questionnaires. Is that correct?
Yes.
Okay. And those are basically our only 2 options, right?
I think the jury commissioner said there's a 1-step option she would prefer with a mailing, or they come in here. So there's 2 basic options.
What's best for you, man, and what's most efficient? That's what I'm trying to figure out.
My job is to serve the court, so I'm going to do whatever needs to be done. I'm not worried about what's easiest for me, but there are certain things that realistically, this timeline in the 2-step, if you do it by mail, I don't think it's going to work, because assuming we agree on all the language and stuff, and I get it to the print shop, it's still going to take them 2 to 3 days to get it printed and mailed, and then postal service, we don't know how long that's going to take. Mostly a day or 2, but again, people don't check their mail every day the way they used to. So, yeah, my preference would be if we're sticking to this timeline and you don't want to do the online, then my recommendation would be to do one written questionnaire and just bring them in like the old way.
Okay.
But then you have to figure out, the same rule is going to apply. Because if you, I guess what we need to know is what is the ultimate number that you need to start what year? What are you looking to start with what year, and what do you anticipate in terms of numbers of excusals? So, I mean, because I work backwards.
And here's my next question: Is 5 to 6 weeks realistic from a time estimation?
Your Honor, as I told you, we're trying to get our direct down to 12 days. Maybe some slippage, but I'm trying to do 12 days, which is 2 weeks and 2 days after opening statements.
I understand. That's why I said 5 to 6 weeks.
Mm-hmm.
I think That'd be nice and all that, but I think the defense has a different perspective on that. But I think 6 weeks is certainly something that I've been saying since the beginning.
That's why I said
We
5
understand
to
that
6.
the court has only, some days has not got a full day, correct?
Right.
Right, so, 6 weeks I don't think is being too far off.
Well, that's why I said 5 to 6 weeks, and that's, all right. So, 5 to 6 weeks, the old-fashioned way, how many would we bring in?
Well, you need to tell me your ultimate number that you need for voir dire first, because I work backwards.
And that's what I mean.
How many qualified jurors are you needing to come in for voir dire? That's the
I think we're
question.
going to need at least 500 to actually come in. We're not counting people.
I
Are you
understand.
talking about after hardships or before?
Yeah, after
hardships?
hardships.
If you're talking about after hardships, you're talking 2,000, and 5 to 6 weeks would not work because I can't physically process that many written questionnaires. You're talking 2,000 questionnaires. That's going to take time because I do those around regular trials.
Okay.
And it takes a long time. In fact, I just did in that other case, we did 1,400 written questionnaires, and this was after that step 2, after the pre-questionnaire, the ability to serve questionnaire, and that took us 2.5 weeks to do 1,400.
Is there a way we can help you process? I don't know what process means.
Not really. I mean, it is what it is. People come in, you check them in, you have to give them attendance, credit for being there, you give them a briefing on completing the questionnaire, filling out the documents. They take 2 to 3 hours, then they get it back to us, and there's certain information we have to enter in the jury management system too, because we notify questionnaire people by email and text, so we have to make sure we have that information in the system so that we can get those notifications.
My thought is 300 people, but that we bring in 100 per day to go through after hardship.
I'm fine with that, Sean.
All right.
I was thinking
Do you have a courtroom to hold 100 jurors?
I don't know. That's a good question. I don't know the answer. You know better. You're in this courtroom.
Well, see, that's all part of it,
jury
too.
management, my jury assembly room only holds 200 people, and I have other trials
I
too
agree.
that are starting at the same time.
I'm just trying to figure that.
Yeah.
If you wanted me to give you a number that kind of works, and now it looks like we've got an agreement on something, you've got at least, here's what I'm looking at as a number. Do it over 3 days. It's only 100. We're not trying to take up all the room. Does that work?
It still doesn't change the number that you got to start with to get down to that 300.
I agree, but maybe that number is only 1,500 on 300.
Well, again, 1,500 took me 2.5 weeks with my staff to complete those written questionnaires, and that was around other trials, and that was doing it 2 days a week.
Okay. Is there a different number that would be better with 300 that the commissioner would recommend?
I'm going to give you what you need. I'm just telling you from the standpoint of timing,
Okay.
what we can accomplish based on our managing other trials and with my staff and getting those written questionnaires done. I don't have one big room. If I had one room and you needed 1,500 jurors to get to that number of 300, say, we do it 1,500 people in one room and be done, but we don't have that kind of facility. We only have 200, and it's very work and labor intensive. You can't just say, oh, come on in and you're gone. There's paperwork that you have to check them in, you have to check them out. It is a process. It takes the majority of the day.
Plus you have other jurors coming in for trials.
Right.
Correct. I have other trials. I have all the other departments, and not just our court. We also do the lower courts, the municipal courts and justice courts. So we're extremely busy. And just to add one more caveat to that, we are transitioning to a new jury management system, which is requiring a whole lot of my additional time. So I'm just trying to be very, very realistic in terms of timeline.
If it was 1,200 that were sent out as opposed to 15, does that make it any better?
A day better. I mean, because again, figure 200 jurors a day, and I can only do them a couple days a week outside of my other trials. I can't do them at the same time as I'm doing my other trials. So you're looking at, if I'm doing them two a week, and let's say I can do 200 in my room at a time, that's 400 a week. That's 3 weeks of just doing questionnaires.
Okay, so I'm trying to find that denominator. I'm trying to get 300 up here, and I need a denominator down here. You're saying that no matter what we do, we're going to get about 60% that responses. And is that the number that I heard?
Well, It's 50 to 60 is what we got. I can't tell
Okay.
you who's gonna respond. I can't tell you on any given day. I don't know. I just know that
So-
typically when I summon jurors, it's basically 4 times what we anticipate getting, because we factor in the people that are not gonna respond. We factor in the fact that people are gonna be disqualified. Some people are gonna be exempt. Some people are gonna be postponed for whatever reason, and then there are some of the medical excusals and that kind of thing. So,
Could I ask
looking
a
at
couple
about
questions?
25%. Yeah.
Eric Pepperman, is there any opportunity to outsource any of the stuff so that there's any somewhat lesser burden on jury services to facilitate things?
I don't know how they can't check them into my jury management system and give them credit for attendance for being here and manage all the issues that pertain to excusals, exemptions, disqualifications. That's not gonna help. I mean, can we do it over? Well, I mean, if we're doing 1 step and not 2, bringing them in for 1, then obviously the timeline's gonna be more condensed. We can make it work. But
I think, I'm at this point now where I think the only way we can do is 1 step.
Okay.
I mean, really, and I think what that does, that alleviates any potential appellate issues.
Okay.
That's my concern, because I want to take that off the table. I don't want to create appellate issues unnecessarily. I don't mind saying that.
Okay.
So if we could bring in
Because
jurors.
Mr.
say-
Kemp will hire a statistician somewhere that says, going to do a study as to the percentage of people that don't appear or because they don't have electronic devices out there. And you know what? And the numbers will probably be true and correct. And that creates a problem, and I don't want a problem, especially if we can remedy it now, right? There's no need for unnecessary Batson challenges. Because I don't want that at all. I don't. I just wanted to make it
I
plain.
thought around the 1,200 number, Commissioner, and Your Honor, is this. That's 25% of 1,200 is 300, if I'm doing my math right. And so with your 50, you're going to get some responses, and half of those is, as I understand it right now, is going to be people that are going to get back to you and say, I can't do it. This is the reason why, and it's going to be a for-cause reason to get rid of those people as potential jurors. That's why I thought 1,200, 300 were on our way, and those are the numbers that I'm looking at.
as 1 step, yes.
As 1 step, that's what I'm saying.
I was just saying I can't do the 2-step in this timeline.
I agree with you. I think we're there at 1 step.
If you're doing the time qualifier as a written, I can't do that within this time frame. If you're talking 1 step within this time frame, yes, I can do it. And can I do 1,200? Yes. Is it going to be a burden? Of course, but that's what we do.
Okay, well,
You know, we do
that's
what we
my
gotta do.
solution.
Okay. Mr. Kemp.
I'm fine with that, Your Honor, because I'd rather have him propose it to the jury commissioner if there's a problem than me. I'm just going to join in his position.
All right. So to facilitate, Mariah, the 1-step process, what do we have to do next?
Well, I should rework this timeline. So we normally just work backwards. So if your start date for voir dire is 9/5/23, you're hoping at that point to have 300 people left that are coming in for voir dire out of the 1,200 that we summoned. So working backward, you would need to have the excusals to me so I can notify the jurors. That's not quite as probably, but around the same time frame for the final notification, 8/29. I don't know, how long will it take you to review 1,200 questionnaires? Then that's where we figure out
Right.
the time we have to have them done by.
Yeah, that's probably at least a week, Your Honor.
I remember I had your partner had to review 500 overnight. Something like that, right?
That was a big pizza day.
That was a big pizza day. Yes.
Plus, council will be here the full week of July 24th for motions, so that takes that week off for review of anything.
Okay.
I think if you start from the 8/7 date of the timeline,
When you say 8/7, you're talking August
because
7th?
we're talking a lot more questionnaires now because we're doing them arithmetic. So I would need 3 weeks to complete the questionnaires. So the last 4 dates could stay as they are. It's just the time frame for the jurors to come in to complete the questionnaires would probably start from that's 3. I would say give me 4 weeks just in case, because I don't know, I could get other questionnaires.
Judge, I think we ought to give her at least another week on top of that because of vacations, the start of school, all that kind of thing.
Yeah, so.
Yeah.
So like, say we start doing questionnaires the 14th through,
You can start the 7th. Is that better, or I don't know.
So June 14th to June 28th is what you were thinking?
no, I'm talking July.
Okay, July 14th.
I'm talking about having the jurors physically come in to complete the questionnaire would be like between the dates of the 14th through August 18th. And then you guys would have from August 18th, or actually you'd have them pick them up on the 21st. You would have from the 23rd until like the 29th to review them. Would that give you enough time?
That's plenty of time.
Okay.
6 days?
Yeah,
I think that's
okay.
plenty of time.
Okay, so I would just say we would start doing questionnaires between 7/14 all the way through 8/18. Because that takes out, and then that takes out all the ASQ part, and then we just need the final written questionnaire within a few days of that 7/14 date. And then just allow me the flexibility to figure out where I can plug them in. And I'll just call them in as I'm able to. And so what I have, we have a separate court location just for these types of cases, and I'm trying to decide if we would probably still make a separate pool or separate pools, if you will, for this case only, because that way we're not drawing from the numbers of the regular jurors. So yeah, we'd probably still go through my special court location. So yeah, I would just need 1,200 blank copies of a completed and approved questionnaire by, like, say, July 10th. Yeah, July 10th.
Oh, they have enough time for that.
Yeah. So if I have that, if the questionnaire is approved,
And we can, I mean, that's
Yeah,
great,
yeah.
because what we can do is we can set a status check on the jury questionnaires maybe mid-June. See where we're at.
so then, and then July 14th through the 18th, we would do the questionnaires, and then we
It's next week.
Yeah, no, I'm saying
Well,
July.
third week of June, you're
You
right.
said mid-June.
No,
But we can do it very quickly.
yeah.
Judge, I'm just looking at the calendar, and July 10th is a Monday. Of course, the 4th of July is on Tuesday this year, so that kind of wipes out the 3rd, 4th, and 5th, I would think. But I would think we ought to aim to get the completed questionnaire to the jury commissioner on Friday the 7th. That way.
And that's the 7th of July? Okay. So I want to have a status check and, or at least do what we have to do at least a week or two before then. So because there's going to be issues regarding the contents of the questionnaire, the description of the case. I know what's going to happen. And the questions, right?
Yes, there is. We've already, we're already not approving anything on each other's side.
That happens every case.
Yeah, so that's not a big deal. I mean, it is what it is. We'll work it out in front of the judge. My suspicion is in order to see which questions are in and which questions are out. I think that's going to happen here, so let's not work it any other way. I think the questions that are in the ASQ, I can tell you right now, because we've reviewed it, and I didn't have a problem with those questions. And frankly, that's going to be the beginning part or portion in my mind.
Yeah, it makes sense.
Yeah.
Yeah, something like that, yeah.
And then we will have to just change up to make sure that we've got the names of the parties figured out with correct spelling so that ASQ questions are all done. You want that by tomorrow, we can see what we can do to get that done for you. You don't need that tomorrow now.
No,
we're not doing it.
because I'm not going to do the questionnaires
Fair
until.
enough. So, but the jury questionnaire will have what is in this ASQ as the first part. That's all I'm saying, and we'll make sure.
Well, I understand your position. Here's my point, and this is what I'm kind of really focusing on, circling back. When would be a feasible time, at some point during the month of June, to have a status check and also a submission of the proposed questionnaire so we can sit down in an afternoon and work it all out?
Yeah, Judge, I think we ought to have 2 sessions, and I would think 2 or 3 hours each, because that, like Mr. Rasmussen said, there's a big divergence of opinion on the questionnaire at this point. And I think probably going to have more judicial involvement than I thought initially.
Oh, I mean, I understand that. You guys would need a couple of sessions maybe. I'm gonna need one session, and I'm gonna go through each one.
What does the 22nd look like for you?
Or you can check our calendar. Would you want afternoons, so you have your whole afternoon?
What do you think, Will?
Yeah, I think that's fine, Your Honor. Start at 1.
I don't know what's on my calendar.
We're open in the afternoon on the 22nd.
All right, so assume that we could schedule that in right now. That'd be my suggestions that we do. We'll try to do what we can with the questions so far, what we've got. Okay.
Oh, that's fine.
Should you pick a second date, just in
1:30?
case?
1:30 on the 22nd.
Okay.
And so, for the record, when we meet on at 1:30 on the 22nd, I would anticipate that you would have already met and conferred regarding which your questionnaires are going to be, and then at that point, hopefully on the 22nd, I can resolve any conflict.
Right. So we'll have one from the defense, and they'll have one from the plaintiff. We'll provide those to this court prior to that.
And why can't you do it this way? Have one, and then have disputed or offered from either side.
Would you like it to be done that way?
I think that might be easier, because then you have to combine them. At least we can, because I know there's certain questions you're going to disagree with, and Mr. Kemp's going to disagree with.
They don't like us asking whether dollars. I mean, I know they don't like that.
Right.
I knew they wouldn't like that. So I was trying to get it down to 5 disputed areas, but we haven't even been.
We haven't met yet.
No, we have met.
Oh, okay.
Well, we have some phone calls, but that is a meeting. I'll get to that.
I think maybe now that the expert depositions are over, or they're going to be over tomorrow, maybe a little more attention to this might be productive.
Well, you know what? The bottom line is this, and I don't anticipate, truthfully, it taking as long as both of you might anticipate, because I'm going to look at the questionnaires and on an issue-by-issue basis. And I think akin with the questionnaire, we do have certain rules and guidelines I have to follow as far as, for example, voir dire 47A. This is part of voir dire, right? Mm-hmm. And then we have Nevada Rule of Professional Responsibility 3.5E. And it deals specifically with the types of questions a lawyer can ask a prospective member of a jury, right? Any basis for challenge. That's what it says, right? And so I don't mind telling you this thank you, Mariah.
You're welcome.
From my perspective, pretty much open as far as questions are concerned. I mean, I do understand certain types of questions wouldn't be permissible, but do what you can, and I'll just deal with it.
All right. We see it a little differently, maybe, but the only reason I can say that is because I am very worried with what I've seen in the RJ and having jurors' information in there, because according to...
No, we don't do it that way.
Okay.
No, on the front page, no. We're more sophisticated than that. You don't put the name of the juror on the front, on the...
Anywhere.
No, you have their badge number.
All right, good enough. If that's the case, then that's going to be one of the questions that we may have agreed to that will be now out.
Yeah, I'm not familiar with this RJ problem.
Yeah,
problem.
But I mean, I'm not familiar with it either. But I mean, for how long have we been doing that, man?
For a long time. We have an actual cover page that I can email to all counsel.
Oh yeah,
what judge likes to see on the first page with a brief description, a real quick hardship question, and then the admonition, and then you can go more into the hardships.
After a trial, then we see the juror identified by name because they gave it to the press, and then the press prints it, and that always is a concern.
I haven't had that.
Okay.
No, because the jury questionnaire just has the badge ID.
The jury questionnaire is from when a trial concludes. Here's so and so who has blah blah blah. You just don't want to see that.
But I don't know if they get access to that.
They don't.
Okay. No, the jury questionnaire, I believe, is accessible according to that
It
case.
is a public document. That's
Right.
why we don't allow the name anywhere on that document.
But see, they don't have the key.
He is the attorney's list with all their names corresponding with the badge and ID number.
See, all we put on is their badge.
Gotcha. Yeah, we've done that before. All right, if that's what we're going to do, then that's great.
Yeah, no, we just
Okay,
have
let's
their juror ID number, and
Fair enough. I get
Right?
it. We got the key. We got it. I understand.
You
know
have it.
exactly where you're going now.
and that's why we do that.
That's what I was concerned with.
Yes.
Because in the ones that have been sent, the name of the juror appeared in the questionnaire, and I was like, yeah, we can't do that.
I agree with you 100%.
Okay.
I do. So that's something we take into consideration. So, Lynn, from our perspective, what do we need to do?
I will pull up our example of the first page, what we need, and if you want to do just the hardships on the next page, that's fine, but and then I'll email it to everybody.
Okay.
And they can see, and you can incorporate that with your example.
We'll try to have a meeting. We'll try to figure out between
You
our
figure
calendars
out,
to have a meeting.
this is how I look at it. I know what's going to happen. Do what you got to do. I hate to put it that way, or what you're willing to do. And I'll see you on June 22nd, 2023 at 1:30 p.m.
Yep.
And ultimately, we might spend that day together. We might have to come back the next day. I have no clue. But when we're done, by the end of the week, we'll have a questionnaire.
Judge, can I ask, do you want us to submit a copy of our single one with the flag disputes prior to the 22nd?
Oh, absolutely, yeah, because I like to review it. And I understand the disputes, but this based on history, it hasn't been that difficult to settle. I guess that's the best way to look at it, the questionnaire, right? I don't anticipate that big of a deal. And the reason why I say that, I dealt with a lot of them in the past, and it hasn't been that difficult of a task, even with high-powered lawyers involved in the case, right?
Your Honor.
I won't say. But we've gotten it done, right?
Fair enough. We will work to get that done, and we'll get something.
And I'm not worried about it because I'll get it done. Either we'll have it done on the 22nd or the 23rd.
Okay. We'll see you back here on the 22nd, Your Honor.
It's a copy submitted the day before, 2 days.
It can be by it can be by midnight on the 21st, because for me, I'm going to look at it the next day or the morning before, and I'll just go through the questionnaire and see what the disputes are. Because let's face it, this isn't like motions in limine, right?
Which we are now, here's based on what I've heard, is that we are now going to be trying this case beginning on September 5th.
Yes, sir.
Okay. And we have motions eliminated to do quite a ways ahead of that time. Are we anticipating moving that date? Are we keeping that date? What are we doing?
We blocked that entire week out, except for the 28th Friday. Judge Williams will be out of the jurisdiction.
Okay.
But I also included this for everybody when you do file your motions. Do put this information on here as far as no hearing. Don't put anything about hearing requested. Exactly. The hearing set on special sessions.
Okay.
Anything we don't get done those 4 days, we just roll over to the next month. Now we have time.
So that document that you just held up, can I get a copy of that today? And
It's in that packet. It's one of the pages. Yes.
Thank you.
It's
Okay.
just to let your staff know.
It's all good.
Just make sure you have everything you need, though.
Right.
We'll do so. If I have to, I will call the JEA and make sure that I've got
I
it.
think we're advised, council estimated almost 100 motions between dispositive and motions in limine. So there's no way we're getting them done.
I think
They won't get done in 4 days, so we're going to go into August. We'll set. I think it's on the
So we have
special master
100
order
is
is
it
where we
100
set
motions?
those dates aside.
More than 100.
I don't know. We may get it 100 and be fine.
some of them are pretty easy, but
I'm trying to figure out what would there be 100 motions on.
Well, I would hope that we'll have our 2.67 meeting and maybe we can kick that number down.
Yeah.
Because I think both of us are smart enough, or all of us are smart enough to know that there are certain issues that are just never going to see the jury. It doesn't matter. We're not going to talk about insurance, for instance.
Yeah, that's
why
not.
have that around?
Yeah, why even?
Right. We already know the answer to that question.
Right. Is that it?
that's it, Your Honor. Thank you very much.
So at least we accomplished some tasks today, so we know what we're dealing with. We got a trial date. It's firm. We will be conducting voir dire on the 5th September, right?
Yes, Your Honor.
And we will have a jury questionnaire resolved no later than June 23rd.
Yes, Your Honor.
And is that it? And I guess we'll have a lot of pretrial motions. I'm trying to figure out, how are there 100 pretrial motions?
There won't be if we can get agreements in that 267.
How would there be? I mean,
You know, you're on the hepatitis case, we had over 60 just on the plaintiff side, if you remember.
well, I understand that.
Okay.
Was there that many?
There was.
How long did it take?
We carried 2 boxes.
Okay, I understand. I guess, when you have bad memories, that is.
I remember framers having 9. I remember plumbers having 10. I remember, depending on what the issues
How
were.
much?
roofers-
How long did we take for pretrial motions in limiting that case?
Well, what typically happens in those two is you'll calls that will get 10 different ones, but then they really are the same flavor. And if you rule on this one on this way, it's probably going to knock out the deck on several of them. So this is obviously a bit different case because each person has some different things. We've got some other issues that'll be before the court on that. So
Okay, well, I'll just deal with it and step by step.
okay, we appreciate your help today.
Oh, yeah.
Thank you.
Anything else we missed, Lynn?
No, I think that's it, unless you want to tell them how you hear the motions that are filed. Do you hear them by the date they're filed, or do they stipulate what they want to hear first?
Yeah, she brought up an important point, and this is what I don't know. Typically, I always hear motions based upon which motion is filed first, right? Because I don't like to pick and choose. However, if you have an agreement as far as what you think would be appropriate to hear first, that's fine too.
Judge, I think usually we do the plaintiffs first, and like Mr. Rasmussen already said, there's a lot of cross motion in each one of those.
It would be nice that there's probably a few motions that I can think of that may be filed that probably need to be reviewed first. My thought always on this stuff is that the dispositive motions tend to be the ones that will do the most good as far as getting things taken care of.
I mean, well, you gentlemen, you can decide to work that out. If you can't, I'll just deal with it. All right.
Okay.
Thank you.
Thank you. I'll give this to Mr. Spurlock
And Lynn, lastly, the motion time period will be again for the record. I just want to make sure I'm clear.
The motions are to be filed by June 23rd per the special master order. That's why I gave you a sample of that page.
Okay.
And
And they're set for hearing beginning, I think, July 24th.
So we're supposed to be here on the 22nd, the day before. That's
That might be tactically a smart thing to do.
Get them done.
You think that's a problem?
I do. I suspect that might be for some folks.
What is that Monday? Is it the 23rd or 24th of July?
The Monday is the 24th of July.
Okay, so if they were filed on the 24th, it would still work because we're going to hear them on July 24th. That's still 30 days.
So if we could move that hearing date for us in the afternoon at 1:30 now, scheduled for the 22nd to the 24th. Is that what you're saying?
No, the filing of the motions.
Oh, the motion of the 24th, that works. Yep.
Okay. All right.
Yeah.
Good.
We're fine, right?
They're
Are you
all
okay?
going to be set anyway, July 24th
That's a
and
Monday.
rolling.
The 24th is a Monday.
Right. Because as master calendar receives them with that little blurb, they're going to start setting them in that order. When they fill this session, they'll go to this session and they'll keep doing it. And then we'll overfill.
24th, we move that from the 23rd. Doesn't make that was a Sunday.
Yeah, they were supposed to be filed on June 23rd. So,
24th. That makes sense.
however you guys want. I mean, for oppositions and reply, if you wait till that Monday. When is June 23rd? What day is June 23rd, Judge?
Friday.
It's a Friday?
Yes.
So, Judge, if you moved it to the 26th,
And we move what?
filing of the motions to June 26th.
June 26th, yes.
And they would still be set beginning July 24th.
Well, here's my point on that. I mean, what is the deadline?
It's June 22nd right now, Judge. It's been that way for June 23rd.
Right.
All right.
And here's my point when it comes to, I don't mind saying this, when it comes to issues like that, I handle that one of two ways. If you agree, I do it. If there's a problem and you need more time, file a motion.
Okay. So right now, discovery is closing tomorrow. So I am requesting, and we'll see if Mr. Kemp agrees, that we can move the filing deadline to June 26th, that Monday.
I'd rather just keep what Special Master Hales had in place.
I mean, I'm going to just tell you guys right now, I'm not going to make any rulings. I don't sua sponte do much. I
I
don't.
get that. So we'll file a motion and get that out.
Yeah.
Can I ask how much? Typically the reply deadline's a week before, given the
Right.
volume of motions. I mean, is that still good? Would you start looking at it a little sooner, or do you want to do it earlier? Because that may help in terms of trying to accommodate any additional time. Just as long as we're getting the replies and everything's fully briefed by the time you want them.
I mean, I want everything a week beforehand. That's probably the best way to say it. And I need everything in binders for me to look at because I'm very much old school in that regard. I highlight, I tab, and those types of things. And I just need paper. I really and truly do.
Your Honor, with that, when you say binders, do you want, because I've seen this a few different ways, do you want, for instance, I represent Hanna Instruments. Hanna Instruments motions binder. And in that, you would like our first motion, our second motion, our third motion, that'll be 1, 2, 3, 4. Assume we had 4 motions. Then what you want, as I recall, is the motion, the opposition, and the reply.
Yes.
Now, with regard to exhibit, which can be sometimes very significant, but also significantly large. Any
Can't you
thoughts?
have this one general exhibit notebook or 2 or 3 and make
One
references to
exhibit
it?
notebook? Okay.
I mean, I don't know. Because I don't know anything about this case from an exhibit perspective. I don't know. I haven't seen it.
So we'll do our best to try to make it organized so that when you're reading it, let's say motion number 1, it says exhibit, we'll say see exhibit binder, exhibit number blah, if that helps you.
I mean, it can be that, or it can be attached as an exhibit directly to the brief.
That's right, yeah, but
It
what I'm worried
doesn't-
about is I've got a binder that's, or do I just do 15 binders?
No, I don't need 15.
I didn't think so.
Yeah, I don't need that.
Yeah, Judge, I think there's some big exhibits here, but I think if counsel just pulls out the relevant page, that would be sufficient.
I agree. I just want to make sure because some people don't understand what he just said, and I get it, and I agree.
Okay. I mean, potentially you can have one general set, but of all the exhibits. But if there's like a certain page or 2 you want me to really focus on, you can attach that as an exhibit to the.
Fair enough.
Yeah.
We appreciate your instructions.
Yeah,
on that.
whatever's makes sense, right?
Okay. We'll get you something to talk about, maybe moving this to the 26th for the
All right.
due date, okay?
That just ruins another weekend for you, you know?
Well, like I have a weekend anyway.
Thank you.
Okay.
Thank you, Your Honor.
Have a good day, everyone. Enjoy your afternoon. Okay.